Good morning, everybody. We're live. Hello, Tina. How are you?
Hi, Callie. How are you?
I'm good. How's sunny
I'm
California today?
sunny. It is a sunny, beautiful day, and we're so lucky because it's not like that everywhere today in the U.S. So I'm very happy to be here, and I'm happy to be chatting with you and your people, and hopefully giving you some good information. And I know you're so awesome, and the people that work with you are already like they know everything. I don't know why you had me here. You're already handled it all.
They absolutely don't know anything, and when it comes to legal stuff, I do prefer people to ask the lawyers.
Look,
And
I don't want to be
anybody
responsible for that.
and anybody who pretends to be what do they say about lawyers? The
Well,
people
they
that
say a lot of things about lawyers. What do you?
the people that represent themselves are a fool. What's that saying?
Oh, well, it's that whole doctor heal thyself kind of thing. Like, don't, yeah, it's lawyers should not represent themselves. Doctors should not treat themselves, right? That whole thing. It's probably, it's a Greek saying. As the Greeks say, why don't you say it in Greek? And then everybody will be like, oh, yeah, okay.
By the way, Tina's also Greek. We've got that in common as well. Hello,
Yes, we do.
Kaylee. We've got a few people dropping in. I'm just
Oh,
I'm
good.
just giving up some time just to make sure that we've
Yeah,
got
yeah,
at least 4 or 5 people. I think
sure.
we're ready to go. All right, so today we're going to be telling everybody about how you have lately been working a lot more with e-commerce sellers, and that's in respect to the Amazon's IP Accelerator program, and Amazon's. Let's just quickly in 10 words or less, tell people what the IP Accelerator program is.
10 words or less. I've never done anything in 10 words or less. But the IP Accelerator program is a group of attorneys that Amazon has vetted to process your application and report it to them so that it's accelerated through Amazon onto Brand Registry.
Awesome. And
That
essentially what Amazon has told you guys is
Mhm.
that we will give Brand Registry faster to people who come through you and whatever other attorneys are in that program. If I'm assuming you're working with them to make sure that you don't process applications, trademark applications that aren't going to go through. So today it's about trademarks, and it's about Brand Registry, and it's about the IP Accelerator program. And this is all in the US, by the way. So this is about sellers who are selling in the US. It hasn't moved across to Amazon Australia yet, although there are big changes coming on Amazon in regards to how global selling is going to be working. But let's just focus on what's happening now. So tell me something about how you think that us sellers should be addressing anything that has to do with trademarks and Brand Registry today.
Well, I mean, I think that trademarks have existed since the time of Shakespeare. So I think it should be part of a business plan. I think that if you have the money to invest in a trademark, it should be something that you're doing. And that is outside of anything that exists in e-commerce, right? So you should do it because it gives you certain rights and powers to prevent others from doing something similar to you and riding off of your goodwill and potentially hijacking your listing or doing things like that, right? You want to have good, solid IP so that you have less problems, right? It's a problem, solver. And so that's what I think is the reason for people to be filing trademarks is it allows you to get some rights and make sure that you're solid before you start getting ripped off. It's preventative medicine, right? So, and then once you're having to deal with a situation, it's obviously better to have it in place, right? So that's the reason that we recommend it. And it seems to be working well on Amazon, better with Brand Registry, and so I think it's always important for people to get their ducks in a row.
So
Right.
we're talking specifically about people who have their own brands on
Yeah.
Amazon. And we're going to try and hone into those people, because there are a lot of people that sell other people's brands. That's a different story again.
Yep.
I'd like to a little bit touch on, and if you can remind me later, touch on those people, because a lot of them end up infringing on other people's trademarks and other people's IP rights.
I mean, you need permission, right? You can't just start doing that because somebody else has those rights, right? You need permission to do those things, right? So anyway,
Exactly.
Go ahead.
So to people who are creating their own brands, and in Amazon's world, we call it private labeling. And for those people that are creating their own private labels, their own brands, essentially, those people are going to need a lot of their IP, and there are different types of IP, but essentially trademarks in particular, and then to create brand registry so that they're protected on Amazon as well. You've got a presentation. Would you like to go through that and explain it through that presentation?
You ready? Should we do that? Okay. Are you able to cast it, or how does that work? There it is. I see it.
Okay. Yep, I think you've got the controls now.
Okay, perfect. I'll give it a try. We'll see what happens. Okay, so I'm Tina Loza. My firm is Loza and Loza. It's let me go to the next slide. Here we go. I started the firm in 2005 by myself, and I hired my husband, and now we're 40 attorneys strong throughout the United States. We do only intellectual property. We're women and minority owned. We do patents, trademarks, copyrights, domain names. I'll kind of give an overview on that. I'm located in California, which means that's where HQ is. And right now, HQ happens to be a little loft space in my house, right? So that's where I'm located. And the firm, one of the reasons that I know Callie and I've been involved with eCommerce and Amazon sellers is because my firm was chosen as one of the Amazon IP Accelerator programs when this rolled out in October 2019. So I've been doing this since that time. And obviously the program has changed a bit over the last year, but I've loved it. I've gotten to work with thousands of sellers, and it's brought me a whole new perspective on Amazon selling and about e-commerce and about how to best support those kinds of clients. And so hopefully I'm a great resource for your people. And anybody who has any questions, please feel free to put it in the chat, or Facebook. I'm super responsive, so I'm happy to answer any questions. I'm
going to want a lot of questions after we're finished with this, so please do start putting them in. I am compiling them, and I'm going to be putting them up on the screen later.
Awesome. I love it. So just really quick, like an overview of intellectual property, because I don't think everybody always has these buckets clear in their head, and it's just so important to kind of have that in your mind. So when you talk to counsel, you have a really good idea of what you're protecting. So patents, trademarks, copyrights, they're the big trifecta. Patents are, useful and non-obvious inventions, right? So you invent something, a new headset, or a new skin for a phone, or, a rotating spaghetti fork. That was the first patent I ever wrote. 20 plus years ago was for the rotating spaghetti fork. But, so I always use that as an example because it's like, just rotate your own fork, for the love of God. Anyway, so, that's a patent. It's a useful invention, right? And trademarks protect source identifications. That's really what we're talking about for the most part today. You see the golden arches, you think McDonald's, you think cheeseburger, you think McNuggets, right? So source identification is a trademark. It's what people think of when they're going to purchase your thing. It's the symbol that represents you, or the word that represents you. And finally, copyrights protect all kinds of songs and drawings and designs and descriptions and instruction manuals. Those are things that come up with sellers, is often the stuff that's inside their packaging, or their packaging itself can be copyrighted. And then under the patent realm, again, you could also protect designs. So you might not have the rotating spaghetti fork, but you can't reinvent the wheel, but you can make the wheel look different every single time. So if you want to protect the way a wheel looks, for example, because you have a cool new sports car, that wheel is protectable under a design patent. You're not protecting the wheel, you're protecting the way that the wheel looks. And that also comes up a lot with sellers, is that they do want to protect the way something looks, and design patents roll out. They're usually issued in about a year. So it's good, quick protection, and it's usually pretty affordable. So that's the little trifecta. Do you want to add anything on this, Callie?
No, there are a lot more things that are different in the USA to what they are in Australia. So there are even the names are different when it comes to, say, patents and the types of patents that come up, etc. So this is a really good base understanding for anybody who doesn't have this information or who hasn't come across it before. I'm impressed. Let's go.
Okay, I just want to make sure you have something to add. So, why are we? What's the point of this trademark thing? Why are we doing this? This is outside of any e-commerce. Why would you bother? Okay, it's to identify and distinguish your goods and services from other people's goods and services, right? You want to be the only one who uses a name because you want people to remember you and buy you again. And if you don't have anything to steer people back, then they'll just go to somebody else, right? So that's the whole point of registering a trademark, is to identify and distinguish yourself from others. And it is a quality assurance and consistency. And I like to use the McDonald's example, unfortunately, because when you go to McDonald's, you know exactly what you're going to get every single time. It's going to taste the same every single time.
Wherever in the world.
Wherever in the world. I think in Greece, I remember I was like, they have feta cheese on this burger. What the hell is going on? But otherwise,
for the most part, they've got the extras. But if you order a cheeseburger in Athens, it's going to be exactly the same as a cheeseburger in Melbourne, and I'm guessing California as well.
Yeah, absolutely. It's always going to be the same. And that consistency, that quality assurance, whatever level of quality that is, that's consistent. And so that's super important for a trademark. And so when you see reviews on Amazon, for example, where someone has bought a product and then they buy it the second time and they say, it was great the first time and then I bought it again and it's falling apart and da 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 da. Okay, that's because they remembered your trademark, and now your trademark, the goodwill associated with it has diminished, right? Because they've had a bad experience the second time, it broke quickly or whatever it is. So what are the benefits? Notice nationwide. So you can go onto uspto.gov right now. You can search for a trademark and you can find it. And it's easy to go on there. Anybody can do it. It's accessible. It's not the most user-friendly or lovely website to look at, but you can find people's trademarks on it. And that's the whole point. Evidence of ownership, federal court jurisdiction. So if you have to sue somebody, you go straight to federal court, which is fantastic. You can use the registration in the US as a basis for obtaining registration in other countries. So I can file in the US and then I can claim priority to the US application if I file in Australia, for example. So that's wonderful. You can get an early priority date. You can record your trademark with customs so that if someone is ripping you off, you can stop their goods at customs. They're blackballed, their stuff is sitting at the port. Okay, if they can't get the product in, you win. You don't have to go to court. So that's a fantastic benefit. Finally, obviously, enforcement rights on Amazon, Facebook, Instagram, eBay, all of these different e-commerce sites and social media sites have a means to report infringers. And the first question is, do you have a registered trademark? What's your registration number? And or in Amazon's case, if you have a pending application, right? So what's your serial number? And if you don't have that, you're shit out of luck. So you gotta be sure that you're getting those things, that you have that ahead of time, so that when you have these problems, you can stop them. And you see it more and more on Facebook and Instagram that you're able to really control the use of your trademark in a really positive and quick way. Often legal means are kind of slow, and if you have COVID, it's even slower. So it's a really good idea to use those tools that allow you to have some results quickly.
Something just popped to mind
Mhm.
that may or may not be interesting to people.
Yep.
But even if you do have a patent, if you don't have a trademark associated with your business, on Amazon, it's pretty damn hard to prove that it's your patent. You need to have a trademark first. If you have a trademark and not a patent, you can knock somebody away from your product, but not the other way around. It's
Yeah.
quite strange how that works.
Well, patent is interesting because it's to show patent infringement, it's very complicated. It's not straightforward. You have to infringe on the claims of the patent. And to infringe on the claims of the patent, you need a really detailed legal analysis.
Mm.
And so Amazon or any third party vendor, they're not going to go through that legal analysis. Your patent is not as valuable on an e-commerce site, for example, because they're not going to do that legal analysis. They don't want to decide one way or another. They're not a judge. They're not an arbiter. They're not going to do that. They're not a
They're
jury.
not even the lawyers that
Trademark,
actually look at them. Yeah.
yeah, trademark, same mark. They're selling the same widget. Okay, done, gone. You know what I mean? It's a much quicker analysis, and sometimes they're wrong. Okay, so it happens, but it's not as likely, and the analysis isn't as in depth, right?
Yeah.
So you'll have better luck with enforcing your trademark more quickly on these sites than you will with a patent. Patents are great, but patents are usually fought out in court. They're not, there's a whole cease and desist letter game. There's a whole, back and forth with counsel. It's unlikely that you're going to see quick results on
And it
social
costs money, so
media.
you better be able to defend it when you go through the process of create. Yep.
Right,
Awesome.
right. I mean, the price point on trademark is also lower, but yes, it costs money to enforce anything, but it's definitely more costly to enforce a patent. You've got that right on, Callie. So, I mean, trademark, everybody's asking me this question, so I always stick it on there. The R means you're registered. The TM means you're using it. So if you have a pending application, you're using the TM. And I always recommend people use the TM right away. They could put that on their packaging right away. It's really, there's no reason not to. And then as soon as their mark registers, they can switch to the R. Once they roll out their new packaging or when they do their next run of packaging. So, it's not, required to happen right away, but it's always good to give people notice that you have a registered trademark.
And it establishes use even when you do apply. Now, something that people ask me quite often is, can I use, do I need to apply for a trademark before I use a TM?
No, you don't. You can just use it.
Just by selling something under a brand name, you
Yeah.
establish use of that name by sticking that TM in there. And as far as I know, nothing changes around the world in the countries that we sell in, including Australia.
Correct. Yeah. I mean, use in commerce gives you trademark rights. You don't need to do anything beyond use in commerce. And those trademark rights might be more limited. In the US, it's more limited without a registration, but you do have rights. You can stop people and you can use that TM as soon as you start selling. So
unless you're infringing on somebody else's rights.
Well, yes, of course. Yeah, don't do that. but ultimately, yeah, your use in commerce is going to give you some rights, and yes, try not to infringe somebody else's trademark. And we'll talk about searching and making sure that you do that. And I know that you tell your people. I know you tell your people to search.
I've got a
and choose
system.
a good
I'll
mark.
tell you about it. I haven't told you about that yet. I do have a system where I before I send people to yourself or any other lawyer, and lawyers actually love me for this. I've got a system of how to choose a brand name before you actually go to a lawyer and ask for a trademark application. We'll go through that later.
Okay. Good. I mean, I can't wait to hear it. So we'll see what you're going to say. I'm excited to hear how you advise your people, because I'm so glad that people are like getting advice on how to do this, because I'm not a marketing person. I'm not going to be the best person to come. I'm telling you.
Exactly. I'm not a lawyer. I send people to lawyers.
Yes.
let's do our jobs and work together. Exactly.
Right. We're so complementary. It's so important that both teams are working for you to like come up with like the best system to make this work. So it's fantastic. Absolutely. But Yeah, I mean, obviously, and Kelly, I know this slide is just, I'm gonna let you just do whatever you want here, but I'm just gonna say, do your due diligence. For the love of God, do your due diligence. Do a search. It's so easy to go on Google. Make sure nobody is selling something with the same name, making sure if someone is using the same thing, that they're using it on something totally different, either entertainment services or something that's not even going to be in your same realm of anything. Because once you choose a mark and you start investing in it and you have to change that mark, it's really tough. So obviously you're looking at Google, you're looking at TESS, which is the USPTO.gov trademark searching system. Go on Amazon, make sure nobody's using it on their brand name, stick it in your domain name, stick it in Google and put a .com after it. Is there another .com that's using it? Oh, look, they're doing the same thing. Okay, move on. That is your signal.
Buy the domain names straight away. I can't stress that one enough. Buy the domain straight away. I've had people go and trademark first and then try and buy the domains, and then they cost them $10,000 because there are actual people that search the trademark register for application and go buy those domains because they know that as soon as somebody has applied for a trademark and spent $1,000 or $2,000 or $3,000 on their trademarks, they know that those people will actually spend another $5,000 on the domain names now too.
Right. And if the domain name's not available, if the .com is not available, move on. This is your chance. Like you're right now starting with nothing. I don't care how much you love the name. Come up with something else, because it's so much easier to do that right now when you have nothing and you can be like, okay, I'm going to buy the domain name for $10. I'm going to contact the attorney. I'm going to do all these things so that it all falls into place. If you do that after the trademark, exactly what you're saying, the thing might be gone already. You don't have a .com. You're doing weird things to the mark. You can't get it. You have a .us or .gov or net or whatever. I mean, my advice is get the .com, get a couple variations. It's what, $10 a month or something like that, or a year, $10 a month, $10 a year. Put it on auto renew. Stick your credit card in there. Don't let that thing expire. You'll feel like a total idiot when you have to buy back your own domain name for $10,000. So that's the way to do it. Absolutely.
I'm going to ask something that I don't even know whether you've covered further on in these slides, but I get a lot of people coming to me and saying to me, well, apparently it's going to be really, really hard for me to get the word mark for this name, and my lawyer is telling me to instead trademark my logo. And I know that you go through logo and image marks later on, but in this instance, we're talking about new sellers that haven't even used the mark yet, that haven't even sold anything yet. I normally tell them change names, change brand names, and change lawyers as well. What do you think about that?
Yeah, I mean, the best, broadest mark that you can file is your word mark. So if you can't get your word mark for whatever reason, you might,
you haven't used it. I mean, it's okay if you've been using it for the last 2 years.
Yeah,
that's a different issue.
Yeah, I think that you should invest if you're building a brand. If you're not just gonna get rid of this in 2 minutes, if you're building a brand and you plan on investing in it, get the best broadest mark you can. Best broadest mark that you can is your word mark. And the way that you get that, I mean, I have some pointers here. I know you have some pointers as well. Don't choose a completely descriptive mark. Okay, descriptive marks are going to end up on the supplemental register. Amazon doesn't allow marks on the supplemental register to be on brand registry. Okay, so if you're selling glasses, don't call them cool glasses. Think of something original, think of something arbitrary. The more arbitrary, the better. Apple for computers is the typical example of the most arbitrary mark. You know what I mean? So choose an arbitrary mark that's the strongest trademark rights come with that, and the least likely someone is using it for something similar, and you're most likely to get your word mark, which is your best and broadest mark, right? Avoid surnames, avoid geographical locations. Kelly, I know you have advice. I'm just going to sit back here, drink my water. You can give the lecture for a little while.
Okay, well, what I normally tell people in this instance before they come to you is get 7 letters together. Put 7 letters together. I don't care if they're the 2 first letters of your son's name, the 2 first letters of your cat's name, and the 2 first letters of your own name. I don't care what you do with those letters. You are going to jumble them up. And then you are going to go into Google and you are going to Google the crap out of that stuff. And then once you've seen that you've come up with a name, and the reason why I say 7 letters, and there's a lot of different, there's things in that I've seen through the years, and there's things about e-commerce that are really, really important. If you go under the 7 letters, I've noticed that there's a much higher likelihood of you ending up using a part of a name of somebody else's name that is already registered and you don't even know it, especially if it just sounds like somebody else's name or sounds like some
phonetic similarity. Yes.
So anything under the 7 letters makes it more likely to infringe on somebody else's trademark, and you probably won't find that out until you're already applied. Anything above the 7 letters is going to move you out of searches. So what happens is, and Amazon is going this way as well, but on eBay, for instance, you've got 80 characters in a listing. On Google, you can only see about 60 characters of a listing that has been entered into Google Shopping, whether it's from eBay, Amazon, or anywhere else, your website, etc. So what we're trying to achieve here is, because on most platforms, including Amazon quite recently, where Amazon has been adding the brand names into titles, what's happening is every single listing around the world on any platform will shortly have your brand name at the beginning of any title. So it's no longer computer with lightning slot. It is an Apple computer. It's an Apple iMac, blah, 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 right? So in that case, if you've got a 20 character title and brand name, like I've seen a lot of people try to use 3 or 4 names in their brand name, right? What ends up happening is it takes up the whole or big chunk of your title, and even if you've got the 200, because not all Amazon listings are allowed 200 characters, some are still allowed 200 characters. That is moving down as time goes by, but even if you do have the 200 characters on Amazon, you're taking up a good chunk of 20 characters just from your brand name. The actual keywords for that go further and further away, so they don't actually index and rank the way they're supposed to, because what Amazon's algorithm looks at is what's in those first few characters. But at the same time, if you're looking at that listing on a mobile, you're only getting that brand name, nothing else, no other descriptor. Most people now do use a phone, and if you're getting that same listing on Google, whether it's on a desktop or on a phone, you're just limiting what people are actually able to see, and nobody's buying your product because they can't even see what the hell it is. They can just see 20 characters of a brand name.
Yeah, I mean, this is the marketing piece that's just so important for people to realize that there's no possible way for me to give that kind of advice, because it's like, I don't know. I mean, now I'm learning obviously from you and others that, you only have a limited number of characters. You don't want to eat it up with a whole bunch of nonsense. I do think that, I mean, what do you think about those 7 letters being something you can pronounce?
Yes, and I always say,
okay. I'm asking you that question because I'm like, sometimes I see marks and I'm like, well, this is just a jumble of crap. Who's going to remember this? And part of trademark is remembering. Like, you have to be able to remember that thing. So
I want them pronounceable and spellable, but I want them to mean nothing. And that is a really big ask. It takes us hours and hours of brainstorming and throwing things at each other until we can actually find that. But the minute that we do, regardless of whether we're definite that we're going to go through with it, the minute that we do find a word like that and we've actually Googled it and we've gone into Facebook, we've gone into Amazon, we've gone into Instagram, and we haven't found anything, and we've tried a few different spellings as well, that same minute we get the .com and the .com.au. This is for sellers in Australia, obviously, because
yes.
we assume that we will at least be operating in Australia and the US. Sure. We get the .com and the .com.au, and they're I can't stress enough why the .net is not as important as the .com.
I mean, all you have to do is say how many websites do you go straight to the .net for, and I don't think I can think of one right now where I would go to the .net or remember it. I would probably go to the .com and
names are taken. All the good names are taken, so we've got to make them up.
Yeah, absolutely. You gotta be creative, absolutely, and you gotta spend some time on it, and you shouldn't be annoyed that you have to spend time on it. You're investing in a brand, it's something you're going to spend some time with, something that hopefully is going to make you some money. So that's what you're trying to do.
Absolutely.
And just like a little side note on the Amazon bit, if you do end up filing a logo because you have to for whatever reason, my recommendation is that your logo piece doesn't have a letter in it. So if you see here, I've used the example of Qualitish, and the logo piece you can see has a Q in it. Well, at the PTO, they say that the literal element of that mark is Q Qualitish. Well, what does Amazon do? They don't just see Qualitish, they see the literal element of the mark and they say, well, that's Q Qualitish. And so whatever is in that literal element needs to match the Amazon brand name exactly for you to end up on brand registry.
So you end up selling on a different trademark to what you think
you're getting Qualitish, but you're getting Q Qualitish, and then you have to make sure your brand name matches up with that. And most sellers do not want to do that, right? And my strong recommendation is if you don't want to have to do that, either file a mark that's not a logo. Again, another reason not to file a logo. In this case, this is not a descriptive mark. It's not my mark. I didn't file this mark. It was just one that I pulled up. But ultimately, it's going to end up in your brand name. So you better be real sure if you're filing a logo that your logo is a flower or something that doesn't have a letter in it, because that letter is going to end up in your brand name and you're going to have that.
So something that I see very often in Australia when people apply for a trademark in Australia and they've opted for whatever reason for a logo is they've got their brand name up the top, say Qualitish, and under that it's best toys for blah blah, and that's what ends up being their brand name. Right. And they turn around, no, that's not my brand name, I can't put that. No, that is your brand name as far as Amazon is concerned, because that is what's coming up in your trademark due to the way that you applied.
Yeah, and I mean I think that's probably one of the good reasons to work with somebody who's really familiar with Amazon. If not an IP Accelerator firm, just any law firm that really has experience with these little things that happen on Amazon that just they mess things up, and it can be really, really frustrating because then you're filing another mark, you're waiting a couple more weeks until you're able, it gets to be a process, and it's so important to have a good Callie on your side where she's like, no, don't put extra crap in your mark, that gives information to the person, or gives just laudatory words like best toys or something. It's just not valuable to your trademark. It's all going to be disclaimed anyway in the trademark, but it is adding to your brand name for Amazon. It's taking up your characters, and you just don't want to do that. So that's just such great advice, Callie.
Amazing advice on your end. We've had a couple of conversations before this about it, and I knew we were on the same page with a lot of things. I've just had a big miff since like 25 years ago when one lawyer turned around and said to us that we had to do an image mark instead of a word mark, and then we paid the price about 5 years later. I mean, I was new at this at the time, and I was green as anything, and that was my first mistake in e-commerce. And I just don't like it when lawyers don't know anything about their client. I mean, essentially, what I've seen with you is that you actually take the time to learn who your client is, and that's so important when it comes to this, because I've got clients that started selling on Amazon 5 years ago, when Amazon brand registry was a totally different kettle of fish. We didn't even need trademarks back then to have brand registry. We could kick anybody out of our listings straight away without having any kind of IP.
Oh,
The good old days.
How magical.
And these clients of mine have got like 2 or 3 word descriptive brands that they've been working with for the last 5-10 years, and that's amazing when they've built a $10-15 million business on that. And you absolutely then need to get an image mark, because if you haven't had a trademark and you've got 10 million riding on it, you need to get something to protect it now, right? But if you're a brand new seller, you've never printed the damn thing anywhere, you've never, or at the very most, all you've done is you've gotten yourself a .com for $10 and that's all that's riding on it, well, throw away your .com and get another name.
Yeah, choose wisely. You're at the best point at the beginning when you're able to choose the perfect mark and like do your due diligence and choose wisely and really come up with something unique and something that you can remember and something that you could own the IP around, that's not going to give you a lot of headaches. And the more, every attorney at my firm is going to tell you a descriptive mark is going to get a descriptiveness rejection. We'd have to file your logo mark to get this through so that you don't end up on the supplemental register, but that's a weaker mark. And I say it all the time and people are just like, oh, I don't care, I just want to get this on brand registry. And it's like, please think broader, think bigger, please. It's not just about that. There's so much else riding on this. I really try. And when I talk to people, I feel really lucky that I do get to talk to a lot of the sellers and they do take the time to make good decisions. But I'm always a little bit disappointed when someone doesn't really think through the mark and really think through how to make it a valuable investment. In the US, intellectual property, it's an asset. It appreciates. Why are you appreciating a crappy asset, right? Like really choose well. So I'm trying to counsel people in that way. And I'm sure you do the same. So yeah, I mean, I think our message is very, very much aligned.
Thank you for your service. Let's go. Let's tell people some more interesting stuff. Let's go.
Okay. So anyway, yes, we've already lectured them enough, right? But here's a couple links. Just FYI links. I'm sure you give this to everybody. It's very accessible. If you need to share my PowerPoint, by the way, Kelly, you're welcome to. I can send it to you later if anybody wants it. But ultimately, here's a couple links that you can just click on so that you could see more about Amazon Brand Registry. You could see about IP Accelerator. You could access my firm if that's something that you choose to do. If you have a pending application at this point, you can get on Brand Registry. So, whatever it is, get on Brand Registry. May I please recommend that you find a reputable lawyer to help you with that. I mean, if you're not living in the United States, you will need a lawyer to help you file because you're required to have a US lawyer. But just, find a good trademark attorney, find somebody who knows what they're doing to get your trademark on file. They do not have to be an IP Accelerator firm. But it's good to have someone who knows what they're doing. Don't always go the cheapest route. You need someone who can really advise you and has a good idea of what's going on. And take the dollars that you have and make a really good investment. And it's important. I think it's important for Amazon and it's important for your brand. So just you be wise about it. The general timeline on how these things work. For my firm, you would sign up with me, you would pay me, I'll do a search, I report it to Amazon. Amazon enrolls you in 2 weeks. So that's what you're looking at in terms of just a timeline. But the 2 weeks is the accelerated part, right? So that's what Amazon is doing now, is creating this acceleration so that you do not have to wait until your mark registers. I believe that at some point in time you needed a registered trademark, right? So that took a year, and you had a whole bunch of people in the world sitting around watching the clock ticking for a year while their mark was getting infringed upon and hijacked and all of that. You do not have to wait that year anymore. You can go ahead and roll your pending trademark in brand registry. And then the PTO is going to look at that application about 4 months after you file. They've been a little slow lately, so I'm just starting to see some movement on applications that I filed in September and October, if that gives people any kind of timeline. It used to be 3 to 4 months. I don't know what happened. Probably, COVID and all the other stuff is kind of taking a toll. Plus, I hear there's thousands of applications being filed because of this program. So, that really kicked it up a notch. And so I do know that they're hiring at the PTO, but it is about 4 to 5 months right now. And then your mark will register once you show use in commerce. Usually a year from your filing is what you're looking at. 9 to 12 months is pretty standard in time that you will be getting a registration.
Yep.
Kelly, you have anything to add right now? I mean, these are just the things that I'm going to ask you for. I'm going to say, do you have these things to file a use or intent to use application? You do not have to be selling yet to file an application. So a lot of people like to get all their ducks in a row and file what's called an intent to use application.
I do have a little bit of a question in regards to what you're about to say, and that's because there's been a recent case. Actually, it's not so recent anymore, but it's a story that I tell over and over because I went through it with one client. So you're going to tell us that we need to apply as either a person or an entity, and some of us are in e-commerce as our proprietary limited, or in very, very limited cases, people use an LLC in the USA if they're located in Australia. But most often than not, it's their proprietary limited company. Would you like to tell us which one? So I can own my trademark. And I can be trading as my own, as an individual, and my company can own the trademark because it is a separate entity. For anybody that doesn't know, a company is a separate entity to yourself, which is why we want them, because they give us that extra layer of protection between what we own and what the company owns. The company can own the trademark, and the company can trade under that, and that is called use. When I own the trademark, because a lot of people turn, but I want to keep my asset and I'm going to put it under my name. But I'm just going to be trading under my my entity name on. I've got the proprietary limited on Amazon, and that's what I'm trading as. What kinds of problems can arise whether I own my IP but my company trades, and vice versa, if my company owns my IP, but I trade under that name.
Let's put it this way. Here's the rule. The person doing the trading, the person doing the selling,
or the entity,
whoever or whatever is doing the use needs to be the applicant on the trademark application. If they are not, then that is not a valid trademark application. It can be invalidated in 2 seconds. And it's completely invalid. And I have seen examiners now going back and looking and saying, wait, that's not the entity, or this is under, Tina Loza's name, but really it's the firm Loza & Loza is using that trademark. so it has the wrong owner, and that is fatal. It kills the application if the entity is wrong.
And what about opposition? If do you end up infringing on somebody else's rights because that, even though they applied after you, or all sorts of things?
If your trademark is invalid when you file because you put it under the wrong entity, because let's say I'm not using it, my entity is using it, but if I put it under my own name, well, the trademark is invalid, and that other person has priority. There's all kinds. I mean, the number of issues that could arise are terrifying. What is the story that you have? I mean, it's so important to make the ownership right.
Very similar. So that's exactly what I want to put into layman's terms for everybody that's watching us today. If you are trading under a proprietary limited, that proprietary limited needs to own all of your IP. It also makes it valuable enough for somebody to buy your book. A lot of us go into business on Amazon so that we can sell our businesses at a big profit. This particular person went into business to sell it afterwards, and they had all sorts of problems when they did try to sell it. They were trying to be smart and then license the IP to the buyer, which is another thing that I want to say to people who want to buy a business, and an established Amazon business or otherwise, whereby the first thing that you ask is, do you have your IP, and who owns it? Is it the person? Is it the entity? And what am I buying with it?
Yeah, absolutely. And what they're going to make you do if it's not under the entity is you're going to have to assign it to the entity. Well, yes, they could license it to the entity, but the person who's purchasing it, the buyer, is buying probably the entity or buying the trademark, and they're going to want it under the entity name. So exactly. I mean, that's it, you don't, and all this needs to be all this needs to be in writing. Okay, you can't just say, oh, I'm licensing it to myself, and just say it to your husband, and then you think it's happened because it happens to be in the universe. No, everything has to be in writing. You have to have an assignment. You have to record that assignment with the PTO. That has a cost associated with it. So it's just so important. If you're selling under your entity, why are you filing it under your name? It just doesn't even make sense. It makes it harder to sell, like you were talking about, Kelly, and most people are in this to eventually sell, but it's also not appropriate. So it can invalidate your mark. It can cause all kinds of issues. And the person the person or entity who's using the mark is the appropriate applicant. And so you need to be really cognizant of that. And I love how you brought in the perspective of, like, if you're going in this to sell, do it right from the beginning, to sell the brand, not to sell the goods, to sell the brand. Bigger picture. Again, we're not just looking at this one transactional thing. You're looking at investing in a brand, and you need to do that in the best way possible, right? So absolutely. Yeah.
Thank you.
You're welcome. I mean, when you see the problems, you kind of, like, in your head, you're always like, come on, you got to do this right. But for the most part, from what I've seen, for what I've done for Australian sellers, we're filing under the entity name. I feel like everybody gets that. Sometimes I'll hear people saying, well, I don't have it set up yet. I'm doing it under my name. Yes, if you're doing it under your name and that's truly what's happening, great. Yeah. We'll file it under your name. And then when you set up your entity, we'll assign it. We'll move it over, or we'll license it, and we'll do it appropriately.
Yeah. So if you're just at the beginning and you haven't got a proprietary limited, you're within your rights to use. Get an accountant. Ask the question. They're
going to tell you to set it up. That's what they're going to do.
They're going to tell you to set it up straight away, because it is risky business to be in it as a sole trader. But at the same time, if you are doing it as a sole trader, remember that one of the things that you're going to have to move over to the entity is going to be your trademark and any other IP that you may have, patents, copyrights, whatever else.
It's like it's property. It's like you have to think about it as like little houses, you little trademark house, your little patent house. It's actual intellectual property. It's like real property, and you got to move it from one entity to another, or one person, or you're moving it into your trust, or whatever it is.
And
right?
a lot of
So,
that has a cost. So if you can do it from the beginning and do it right, that makes
yep.
perfect sense.
Do it once, do it right, never do it again. So that's the way that it goes. I agree with you. And so, it's been up on the screen what I'm going to ask you for. I mean, you've made the great point about who the applicant is, who the owner is. Don't just tell me you have a trademark and you have no idea what the hell you're going to sell. I can't come up with that for you. I'm not going to tell you what to sell. That's not my job. I can't file a trademark unless you know what you're selling. So you better come to me with some goods or goods or services, but usually for Amazon it's goods. Come to me with a good that you're selling or that you are intending to sell. If you have no idea what you're doing, then you're coming to me prematurely.
I do need to make another point here.
A
lot of sellers have no idea what they're going to be selling. They're still at the research phase. If this was like 2 years ago, I wouldn't even be making the point. It's like, when do I start a trademark? When you have a brand and a product, not now. Just start selling on that brand. Today it's getting harder and harder to do that. So even if it's your first product and you do have an inkling of a product that you've started to sell or started listing on, etc., by all means start a trademark application. Trademark applications are expensive. The second one that you do on a second product is going to cost you just as much as the first one. So
I mean, yeah. I mean, I have such a hard time with this part because a couple things. One is whatever you file for, you can't, once I file, I can't add to the application. Okay. And once I file, if we file an intent to use application and say, oh, okay, I'm going to sell bags. Okay, great. You're going to sell bags. And then you come to me 6 months later to file your statement of use and you say, oh, well, I never sold bags. All I sold was shoes. Well, then I can't file your statement of use. This trademark is not useful to you. We need to refile with shoes because that's what you're selling. And in 5 years, I'm going to come back to you. Let's say you do sell bags and we register your mark. And then 5 years from now, I come back to you and say, okay, it's time to renew your trademark. You got to show that you're still selling bags. And you tell me, oh, I stopped selling bags 4 years ago. Now I'm selling shoes. All right, well, your trademark is now useless. We need to file a new trademark. So please, whatever we file for, be in it for the long haul. That is a good that you should stick to.
The problem is that Amazon won't even let you list these days without a brand, a registered brand on their platform. And a lot of sellers will tell you that they've bumped into something called Error 5665, which pretty much tells them that they can't list their product because they're not registered with Brand Registry. There are ways around that, and I would much prefer people use those ways, which essentially means that they're showing that they've got a product with their logo printed on their product packaging, etc., until they know that they're actually going to be selling that product. But it does become really, really difficult when Amazon is seeing the bags trademark, letting me list under that bags trademark shoes and
you can sell anything you want on Brand Registry, regardless of what your trademark. As soon as you're on Brand Registry, you can sell anything on that brand. Amazon doesn't care.
Which is why we do it. We do it. We throw away $1,000 or $2,000 for our first trademark, so that we can actually list anything on Amazon for the next 5 years until we find our feet and until we figure out what products we'll be selling long term. So
yeah, you need
it's
to communicate
not something I would have advised.
Yeah, I mean, you need to communicate with your trademark counsel about something like that too, though, because if you tell me like I'm not really sure, but I think it's going to be something in this like list of goods, it's going to be some kind of whatever. I mean, in an intent to use application, you could file quite broad if you have an intent to use, and it might be, 10 different things, clothing, but you don't know what clothing. Well, we could list a lot of different types of clothing, as long as you have an intent to use it, and then something's going to work in there, right? But if you only list one thing, like shoes or bags, and that's not what you end up doing, then you end up in a trademark thing. But I mean, I work with sellers all the time on this. You just need to um, just get really good counsel on it, and get
Good
good
advice.
information, get
Exactly.
just get good information on it,
Just
and make the best decision that you can. But do know that you're going to have to be using it to get a registration. Whatever we file for, you're going to have to end up selling that thing, and to renew it, you're going to end up having to keep selling that thing. So, or we're going to have to
And
file a new
trademark classes aren't Amazon categories. And talk to Tina Loza when you have those kinds of questions, or to your own lawyer if you've already got one.
absolutely.
Nobody's going to take you away from a lawyer that you already trust and
Oh yeah,
respect.
absolutely. If you
But
yeah,
but
go
this
ahead.
is the kind of advice that you need.
Yeah, absolutely. I mean, yeah, it's a big decision, and you should be making it with counsel. And if it's not me, please choose an attorney. Just go talk to somebody. Make sure that they're a trademark attorney, that they know what they're doing. A lot of great trademark attorneys in the IP Accelerator program. Lots of great trademark attorneys in the U.S. I know lots of them. And you just need to find somebody that you would like to work with, and work with them, just like
And
anything
they
else.
understand your
But
business. Very, very,
yeah,
very important.
yeah, I can't stress it enough. But here, let's make sure. I think we kind of talked about that already. And then if you want to, again, here are some links for different IP Accelerator in the EU is up now. And if you want details on any country specific requirements, I also have that link up in the screen for everybody to take a look at. So just go on there, and you'll be able to get some more information about that. And I'll send out the PowerPoint. So
In
that
Australia, we don't have IP Accelerator. However, there are a lot of companies that have already started selling in Australia before they go to the US and before they join up on Amazon. With those ones, what you usually recommend, I'm guessing, is that they use the Australian trademark as a basis, or
it really depends on the timing. So if we can use the Australian application or registration, we will. If we can't, then I'll just direct you to direct file in the US. It's very fact specific. So I want to make sure that I kind of look at the facts, and then I can advise properly. But usually, if I can claim priority to an earlier date, I try to do that.
Mm-hmm. And always give that information to your lawyer. They're not going to guess.
Yeah,
Also,
we're not clairvoyant. We're a lot of things, but we're not. Don't just know things. So it's good to give us information. Yeah, don't lie to us, and don't keep information from us. The more we know, the better. Trust me. So.
awesome.
But I think that's pretty much what I have. I'd love to take questions. I don't know if we're on a time limit. Are we on a time limit?
Not as far as Facebook is concerned, so we're going to milk this.
Good.
There already are a couple of questions here, and guys,
good.
while we're talking, please do start adding your questions to the mix. I'm going to get rid of this now. Now, this long question, I'm going to put it on the screen for a short time, because it's actually going to take up the whole screen and cover
up. Let me read it. I've applied
Let's read it first. Hello, Rose. Thank you for the question.
Hi, Rose. I'm reading. Hold on. Give me a sec.
I've applied for USPTO with my unique spelling of commonly used words. I've also applied with IP Australia. If I have been rejected in the US as the word sounds like an existing word brand, and I'm going to guess you're going to say something like I'm going to say here. If we don't know what the word brand sounds like, then this is going to be very, very general in terms of an answer. But however, it appears that it may succeed in IP Australia. I plan to sell in both marketplaces. If I achieve registration in Australia, is there any way that I can sell under that brand in the USA? And I'm not sure what EU, where can we find information on the EU regulations around trademarking? I'm going to ask you to answer this because we don't know, Rose. I'm sorry, Rose, I don't know your business, but I'm going to ask you to answer this. As if Rose is a brand new seller that has not used the trademark before, what would your advice be in a similar case? And if Rose has already been selling, so different case, if Rose has already been selling for like a couple of years and has had her, she's been selling on that brand name for a while, what would you normally advise in those two cases?
Right. I mean, first of all, if you get a rejection in the United States, there's ways to often argue them. So you do have 6 months after receiving a rejection to potentially put some arguments forward to try to overcome the rejection. The second, not selling yet, but ready to launch in 3 months. So if you're not selling yet, and it looks like you're not going to be able to get that registration in the United States, this is probably a chance to rebrand. Just because, if you're not selling yet, you haven't invested in the brand, you will get some limited rights in the US, but
usually people are worried about the $1,000 or so that they've spent on applications. I think you'll agree with me when I say that $1,000 is nothing compared to what you can actually lose in the long run in the future.
Well, you already know that the PTO thinks that your mark is confusingly similar to another mark, right? If that other party also thinks so, then you might be in a heap of trouble in that sense, right? But if you're not selling yet, it is a good opportunity for you to consider rebranding if you have a phonetically similar name that's already triggering some concern. Will you have rights in the United States? You'll have some limited rights. Your rights in Australia are not going to really help you in the US. I do not think that they help you on brand registry either. I don't think you can use your Australian IP rights on US. You can on US brand registry.
You can for listing. You don't have to protect the protections, but you can list your brand in Australia, and any brand that has been listed in Australia can be transferred and used through brand registry. So something that is coming up is that every single Amazon marketplace in the world is being merged together very soon. It will allow you to list in any part of the world. However, if you are selling in the USA with a mark that is similar to somebody else's and they have brand registry as well based on the USA mark, then they can bring your products down on Amazon USA.
Okay. So I think we teamed together and we gave the answers to that question. In terms of and Rose, you can also check on EU rights. I don't know exactly what your question is, but EU IPO, you can search to see if there's similar marks in the EU using that route. So that might be a way that you might approach it, but I've already rebranded, but I really want the original.
I smile at this. She's attached to the name, and it's too early yet. There is no such thing as an attachment to something that has not yet produced any kind of fruit. This is business. It's not your baby. I know that it feels like it, and I know that it will be while you're and you do want to love your business, but the name is not necessarily that.
Yeah, I mean, sometimes there's a way, but it sounds to me like I'd have to see I mean, it's just so specific, and I can I'm a lawyer. I'd love to argue, argue it, but ultimately, if you already know that something is a headache, why pursue it, especially when you're so early in the game, right? So that's just, I think we
cut your losses, Rose. Cut your losses.
Sorry, Rose. Sorry.
Talk to Tina.
It's always the worst. It's the worst news when I have to tell someone that the name that they're so attached to is like, I'm like, no, I'm so sorry, and they're like, but I really want to, and it's like
it comes down to weighing up the pros and cons, and in business, it's all about money. What's it going to cost? And what are you going to lose? That's essentially what it comes down to. If you'd been, if you'd printed it on 5,000 units of a product, we'd probably be, No, it's it'll make your life hard. It'll make your life really hard.
Tanya.
We have thank you, Tanya, for the question. We have another brand who have registered our brand name, but under our category 21, which they have not used. Oh, I think I know what Tanya's referring to. I had her in a Zoom call recently talking to me about this. I can't remember the exact details though. So there's somebody who's registered her brand name in a different class, in a different class of product. I don't even think it's a product. It's a service class. Yeah. Can we advise they never use their registered name and it's not in their category?
So the question's a little confusing, but I think I can kind of I could take it apart a little bit. One is, two people can have the exact same mark, and if their goods are highly unrelated, then it's not a problem. Both parties can receive a registered trademark. Both parties can use that trademark. It's not a problem at all. So if it's category 21 and the person is selling spoons or something like that, kitchen utensils or something.
I think it's more like 40 or something. So it's some kind of a service mark.
Okay. And then, if there's a service mark, it's usually not going to, unless it's like online retail store services selling the same thing that you're selling, that's a little bit different. But ultimately, if it's a service, mechanic services or something, and you're selling cosmetics, that's not a problem. The goods are unrelated to the services, you're going to be able to get that mark. There's a sliding scale, right? So I kind of try to see it as if the marks are identical, the goods and services have to be unrelated for you to get your mark. If the marks are similar and the goods are related, then it's kind of more of a legal analysis. Is if the goods are identical and the marks are totally different from one another, then also not a problem. So you kind of have to make a legal assessment and make that decision. But obviously, if two marks are identical and the goods are identical, this is your opportunity to move on and choose a new brand.
I think she has some kind of an opposition. I can't remember the exact case. Tanya, if you do get a chance and you're still watching, please do come and clarify exactly what the question is, because I'm an old woman and I don't remember. You already know that. Okay, so Doug is asking.
Doug put something up earlier today on Facebook too. So
yes.
That. Okay, go ahead.
I have the first run of 2,000 products already created with the name on it. The trademark was then rejected as confusingly similar to another mark. I have brand registry with Amazon already. I'm not in love with the name. Go forward or start over with another name. Can I put my 2 cents in regards to how they actually work on Amazon?
Please, go ahead.
So, Doug, you can actually rebrand on Amazon. It's not an easy process, and you do have to time things really, really well. But as the brand owner, if you get a secondary mark and you've got it in the same brand registry and connected to the same seller account, you can actually switch from one mark to another. I don't recommend that you do it willy-nilly, but if there is a reason for you to do it, it is possible, because that's usually the biggest problem that people have. They've already sold for a while. They get all those reviews on their product. The ASIN then has to come down, and they have to start fresh with the brand new trademark, brand, and ASIN. So it is possible. From there on, let's say from a legal point of view, what Tina will tell us.
It's so specific. If you get a likelihood of confusion rejection based on another mark, I mean, we overcome those rejections every day. So sometimes we just need to make some arguments to try to overcome the rejection, and it'll be fine, and you might be able to continue on with registering your mark and moving forward. But it really just takes us to, if you have your attorney take a look at it, and they'll say, okay, I have 0 chance of being successful with this. I think I have a 50-50 shot. I think listen to whatever the attorney says. If they say that they're not going to be successful, you should listen to them, because there is a cost associated with filing a response to an office action and trying to argue it. You're not selling it yet, but
he's printed it on the products. So
yeah.
It's a cost versus benefit.
It's just, it is a cost versus benefit analysis. If you're not in love with the name and you know that, you want to just get rid of the first run, you get rid of that first run of product and then come up with something else. Maybe this is your opportunity to do it. It might cause you less headaches down the line. But again, without, knowing the marks and all that, I think it's, it takes a little legal analysis. But if you already know, I'm not selling it, I'm not in love with the name, I only have a first run of 2,000 products, and you want to get rid of that and maybe come up with something else.
And it costs either way, exactly. So it's really a legal issue. You need to talk to the lawyer that you're talking to, because or get another lawyer. Here's Tina. But
no, I think Doug is working with somebody at my firm already. So
awesome. Right. So
she's great. So
awesome. So ask your lawyer what it's going to cost to oppose this, and what it's going to cost to start a new trademark application. Put that together with what it's cost you to print whatever it is that you're selling, and long-term cost, and see if it which way is best to go. But yeah, if you're not in love with it, I think the easy way out is to just go for another name.
I mean, and also, Amazon Brand Registry will stick around all the way until your mark goes abandoned. And so you have 6 months to respond to an office action. So if you might have this 6-month period to get rid of it, and you'll be on Brand Registry that whole time. And then meanwhile, you're already thinking ahead on transitioning to your next brand. So
and this product might be a dud and you don't even know it.
It might be a blessing in disguise, right?
You've got an exceptional chance to test it out while you're figuring yourself out in terms of brand names.
Right. And I know that I know the attorney that he's working with, and I know she'll give him good advice around how to strategize on this. So, I know everybody at my firm is fantastic, and they'll all give them great advice. But ultimately, I think just kind of talk through the pros and cons of responding, not responding, what to do here. And but it sounds like you've already convinced yourself that you don't love the name. So, sometimes people are talking themselves out of things and into things. So
yes,
I think he already knows what he wants.
Absolutely. And I like that. The I'm not in love with the name is what I wish everybody would do.
I wish no one would be in love with any name ever, because it's just too disappointing. We received Tanya is following up.
An adverse examination report as a large brand has the same brand name. They have held it for 10 years, inherited from a takeover, and never used it. They have listed 3 categories, including 21, 3 classes, she means, trademark classes, including 21, which is ours. They have never developed the brand or any products. Yes, I do remember this now. What does an adverse examination report mean?
I don't know. Do you know what it means, Kelly?
No, I have no idea.
Is that an Amazon language? Because that's not trademark office language.
I think that's IP Australia language.
Okay.
or a legal. So essentially,
it's not a USPTO language in the United States. If you're not using the mark in commerce, then you can't keep your registration. So if somebody has a registration,
I think that it's part of TM Head Start in
Australia.
Australia, adverse examination report. It is coming up. It's a yep, it's IP Australia language. Do you want me to bring it up on my screen?
You can. I mean, I'm guessing that.
So essentially,
I know enough about. I know a couple things about Australia, and I know that you can. I think that you're able to go ahead and report that non-use, and sometimes that you're able to put in a declaration and try to get around that, but it takes time and money to do that, right? The same thing would be true in the United States. You could cancel that mark if it's truly not being used in commerce, but only Australian counsel is really going to be able to answer this question really well. So
let's see if you understand this better than me. This is on the IP Australia website, and it's talking about adverse examination reports. If your trademark application does not meet our legislative requirements, you will receive an adverse examination report. This is usually at the TM Head Start point. The report will outline the reasons why and any options for overcoming them. The report will contain contact information for the examiner assigned to your case, so you can call us to discuss your report or seek more information. This is for people who are trying to apply for their own trademark without a lawyer. You normally get a phone call or an email by an IP Australia attorney who will then give you a heads up of whether or not it's a good idea to continue with your application. You might disagree with our assessment of your application. If this is the case, you can also submit your response or argument in writing. You have 15 months from the date of the adverse report to address any problems with your application. This is something that's going to take a long, long time. And I would suggest that Tanya, and I think I've already told her this, to speak to an Australian attorney about it. But at the same time, anything that takes time and anything that takes extra money when it's a name that you haven't used in business yet. What do you think, Tina? Let's repeat ourselves.
I mean, if you haven't, cost benefit analysis, like this is business, baby. So, don't invest a whole bunch of money in a loser, move on, choose a new name. And especially if you're not selling, it's actually an opportunity to choose a new name at this point and cut your losses.
You've got some amazing fans in the audience.
Thank you.
And yes, we got that, Tanya. Look, seriously, you either speak to an Australian attorney and see what it's going to cost you and what they think in terms of timelines.
What's your chances? Yeah.
Give it up. And you know what's amazing that you're probably not going to believe. Our trademarks, we can do them very, very easily online. We don't need a lawyer to do them. We can do 20 a day if we want to, and they only cost us $330, including TM Head Start, which is a personal phone call with an IP attorney from IP Australia. The costs compared to the USA are totally, totally different. I always recommend that people just go for the Australian one straight away, even if they're not sure about other things.
That sounds much easier.
So easy, so easy. I've got loads and loads of them.
We have a question here. How likely would USPTO see an issue in a word that has a meaning in another language, where the word translation to English is used by someone else when the language is not widely spoken or known in the United States?
I think something to the effect of, say, casa instead of house. So somebody's got the word house in the in Australia, in the USA, and they're trying to use the word casa. kind of thing.
Yeah, so there is something called the Doctrine of Foreign Equivalence. And so the United States Trademark Office, when they're examining a mark that is in another language, will translate the word. So if it's casa, which is home, then they'll go ahead and say, is there another home mark in connection with the same goods and services? Okay, this would be confusing to a consumer, and they'll still reject you even if it's not. It's in two different languages. Now, the second part of the question is how about if this language is not a commonly used language? Let's say it's a dead language like Latin, or it's a language that most US consumers are not going to stop and translate. And if that is the case, then they still ask for your translation, but you might not get a rejection, or we might be able to argue around the rejection and say, listen, it's unlikely that any US consumer is going to stop and translate this. And so even though the Doctrine of Foreign Equivalence is there and you can translate it and cite this mark against us, most people are not going to stop and translate this mark. Now, if it's a common language, if it's French, if it's Spanish, for sure, Italian, anything like that, you're going to probably get that rejection. I've seen Russian, the
And
commonly
especially if
used.
the root is the same, because a lot of languages have
Yeah,
got
I
words.
mean, come on. The Greek word is in everything. So let's be very clear. But, ultimately, it really depends on whether that US consumer is going to be able to stop and translate, and what percentage of consumers are going to be able to do that. And there's some languages that are just not spoken widely in the US, and so that's not going to happen as often. And
I got a
so
rejection for my translation agency name back in the day for metaphrase, because I said it's a Greek. No, but it's in the dictionary. You can't have it. Sorry.
Yeah. So
Yeah.
absolutely. So yeah,
I
I
did.
mean, you would just have to let me know what it is and how much the word, how, and I'll let you know if I don't think you're going to get it. I'll tell you. And
But try and get something that means nothing anywhere.
that can be a little challenging. Yeah, I mean, I've had people who have chosen a name that I don't see any translation for, and so I
And
don't
then
know if it's
there is. And then you look on
PTO,
Google, it's some Indian.
and then there's and then the PTO finds a translation, and you're like, okay, but just because the PTO finds a translation doesn't mean that you're doomed, especially if it's not commonly used and people wouldn't stop and translate that word necessarily. So, translations happen, and sometimes they'll ask you, does this word have a meaning in a foreign language? And you're like, not that I
Not,
know of. I just made this up. This is half my name, half my wife's name. I've seen that a lot, but it does end up having a translation somewhere. And just because that's true doesn't mean that it dooms the application. So I wouldn't, it's not necessarily, you don't need to panic about it necessarily. So,
and that's why you've got a lawyer.
yeah, it's nice to have one of those sometimes.
Rose, yes, I appreciate your
Oh,
direct.
good. Rose doesn't hate us. Poor Rose.
Please give us another name, Rose. You will thank us
Oh,
later.
maybe,
Actually, you
maybe.
probably won't thank us. It's one of those things where if nothing goes wrong, you never know that it would have gone wrong otherwise. But
Right,
please
right.
do believe us. We've seen a lot. Tanya needs to chat with you. Awesome,
Tanya,
Tanya.
that's fine. I'm not an attorney in Australia though, so if it's about that adverse experience, I'm not going to be able to give you a lot of advice.
No,
That's more
she needs a US one as well.
but if you
She's
need U.S.
trading.
counsel, yeah, reach out to me. Happy to chat with anybody anytime. Happy to. So don't worry about it.
Absolutely. That's why that's why we're here. Which is why I registered my dad anyway. But it's so good. There you go.
Oh, Rose, I'm sorry.
That's all right. That's okay.
Yeah, Estonian is probably not going to be a stop and translate kind of thing. It's unlikely that a US consumer is going to stop and translate that. So I think you're probably okay, but
Depending on the
depending on what it is, especially, I mean, yes, you're probably fine. But again, I'd have to know a little bit more to give you perfect
The root
advice,
might be
obviously.
Greek, and then it means everything in any language.
Yeah, and yes, exactly. Everybody's stealing from the Greeks as far as I'm concerned. So,
Do you remember My Big Fat Greek Wedding
of
and
course, of
Mono?
course. That movie was the story of my life. I don't think that there's any word that my mom was like, this is a Greek word. I remember studying for college entrance exams and she was quizzing me on words and every word was like, oh, this is a Greek word. I already know what this means. This is a Greek word every time. So, all right.
Tanya
Good,
means
good, good.
USA and more, or
Good.
some. Tanya, you know where to
Awesome.
go now.
Thank you.
I don't see anything else unless there's something in the group itself that hasn't actually translated into my StreamYard feed. If you'd like to say a few more words while I do some searching on the broader internet,
I guess
I'm
we can just, we'll reiterate a couple of the things, do your due diligence, choose your marks wisely. I think those are the big messages that we've heard today from both of us, right? I mean, that those are two things to always think about. Just, make good choices when you're doing your marks. Check online, check test, check IP Australia, check all the smart places that you would check to make sure that no one else is using it. And don't be wedded to your name, right? So if it ends up being a dud, as Rose called hers, be ready to change. It's not on a birth certificate or anything. You're able to kind of switch these things around. So see it as a learning experience, as an opportunity, and just remember that if you can do your due diligence early, you're not going to end up with those issues as often. So you can always reach out to me. You have my information on the screen. If you reach out to my firm, my team is fantastic. They're smart, they're responsive. We get back to you real quick. It's really important to us to be responsive. So if we're awake, we usually get back to you right away, which is not always the case when we're working with Australia, but we still try really hard to be responsive. But even if you don't work with us, please, have an attorney help you with your trademark application. It is a complicated process, and there are certain rules, not only with the trademark office, but with Amazon, that I think that if you can find someone who is a trademark attorney, they'll get you through the PTO and give you good, solid advice. But if you can find someone with some e-commerce experience, I think that will benefit you a lot. And so you should really be looking for someone in that space. Doug is asking another question. Hi, Doug. Thank you.
Should I only have one brand name and use it for multiple products, even if they are not the same category? I have seen successful sellers with 30 plus unrelated products with totally different product names.
Kelly, this is a good one for you. I can answer it, but in the trademark side, I think you should take this one first.
We should both answer it. So from the point of view of when it comes to Amazon, go ahead, sell 30 products on the same brand name, so long as you're not infringing on anybody's trademark. So essentially what you're doing is taking advantage of Amazon brand registry, which up to now, and this does not mean that nothing will change, things change on Amazon all the time, but as of today, the 21st of February 2021, or the 20th of February 2021 in your case. We're talking to you from the future. As of today, we are able to list multiple products in multiple categories with one class of products protected on our trademark, and that gives us brand registry for all of those products. On the other hand, that's why I choose the 7 letters, Google it to death, don't find anything in any class category, etc., is because if you're not too sure about where your product is going to be going and whether or not you'll be in a different class of products later down the track, you want to make sure that the word that you're using is as broadly as possible.
Versatile. Yeah, it's versatile.
free, etc. So from a legal point of view, go ahead and tell us, Tina.
Yeah, I mean, legal point of view, we could file in one class. You could use it in that one class. Your use is not limited to that one class. But ultimately, your trademark rights are going to be for that mark in connection with those goods or services. And you'll only be able to stop people who are using that mark in connection with those goods or services or related goods or services, right? And you do have some common law rights, but the best trademark rights are your federal rights. So if you start selling a lot in another class or category, as in Amazon speak, if you start selling in another class and you're getting some traction and you want to be able to stop somebody if they're an infringer, you might at that time decide that you want to add a class for that better trademark protection. But you do have some trademark protection just based on your use. And so, you certainly can
Your
do it.
first
Test the.
trademark isn't going to be your last trademark, Doug. Start with one because we've got the issues that we've got in on Amazon, but from there on, it does not mean that it's going to be your last one. You're going to need your trademark lawyer for a long, long time, and I'm glad that you've got Tina's team on your side, because you're going to need them for a very, very long time.
Oh,
There you
good.
go.
Thank you so much for using us. I'm happy.
Another happy client. I'm
Okay,
so
good. Thank you. Thank you. I love it.
glad that Kaylee's been using you, and you've got a lot of fans here.
I love it. I love it. Thank you, Kaylee. I don't know who you worked with. I don't think it was me. I'm not great at names, but I don't think I've had an Estonian mark yet. So I don't think it was me. It was somebody else, maybe.
Somebody
But
in your firm, and it looks like
yeah,
you've cherry picked your partners, and it
they're awesome.
sounds like you've got something really good happening there. From my point of view, she's just answered that it was Samantha. Oh no,
Oh,
hold on.
Samantha's awesome. Yeah.
Yeah,
Yeah.
and I'm thinking the one I have is not the one I want, but it's the one I have. Exactly. So use it while you have it, and in the meantime, jump ahead to something else. I already have a US IP lawyer, but you are very insightful, and I appreciate the second perspective. I'll call if I need to delve further. Awesome,
Great.
Rose. I'm
Thank
glad
you,
that
Rose. Yes, definitely go back to your attorney if you're comfortable with them and you love them. I'm sure that they'll give you the same
and one
advice that I
and,
do.
and one thing from my perspective, your lawyer needs to be asking questions about your business. If they have no idea how long you've been in business for, if they have no idea about your products, about if they haven't taken 15 minutes at the beginning of your relationship to actually understand what it is that you need, they are not going to make good decisions for you from a legal perspective. And I don't care how good they are as lawyers. This is what I see different in Tina. Tina is understanding her clients. She's understanding us as e-commerce businesses. She is giving us advice that has to do with our businesses and not putting blinders on. This is a quick $1,000 and let's quickly push through the application, because that's what we care about. That's not what we want. and quite frankly, I don't care whether you're saving a couple of $100. That there's really not very much room to move when it comes to legal fees, when it comes to trademark applications. They're broad, yes, but not as broad as you might think. There's not very much more that you can save than, say, $300 or $400. And if there's somebody that's going to not even know who you are, not even give you the right kind of advice for your circumstances, because they're trying to keep their prices low, that to me says that you're not getting your money's worth, even though it could be that. Now, one last thing about IP Accelerator, and we touched on that a little bit at the beginning, but IP Accelerator is an ongoing program. But as you said earlier, we can now apply directly for a non-registered mark for brand registry. What I want to say is that in terms of getting your application moved faster and in your brand registry move faster, IP Accelerator is still the way to go. And I don't see that Amazon is going to stop the program anytime soon. But at the same time, you can use what's called a serial number in lieu of a registration number. That essentially means that these days you can apply for brand registry earlier than when you're come on.
Earlier than when you registered. Yeah, you don't have to wait until you have a registered application or have a registration number. You can use your serial number, and you get your serial number the minute you file your application. You push submit, and the serial number comes back to you, and that's what you use when you apply to brand registry. So
thank you for that. I was latching on to that.
It's fine. It's fine. I mean, I'm saying it's like 7:30 now, so my brain is starting to turn off a little bit.
We're going to bid you. Let me see if we've got something else here quickly. Thanks for the meeting. It was a pleasure. Thank you very much.
Nice meeting you, Doug.
Yep, and that was it. That was
Okay,
the last.
cool.
Okay, so thank you so much, everybody.
Thank you.
Well,
Kelly, thank you. Thank you for having me with you on this Saturday night, Sunday morning. I loved meeting you and chatting with you. It's been so much fun. And if you ever want me to just chat with you again, you just let me know. I'm happy to jump on and
I was just going to say until next time. I'm hoping that I can lure you now that everybody's in lockdown. I can lure more people into this platform.
Absolutely. And I'm on your page now. I'm on your Facebook page right now. So if anybody jumps on with questions, I will answer if you want me to. And you could just say, hey, Tina. Yeah, I'm happy to answer questions and see. And then I'm very accessible on Facebook. You found me on Messenger and I answered you right away, right? So
I love it.
Yep.
So guys, if you're in Amazon Sellers Australia, USA and Global in the group, Tina is a member of that group now. You can tag her just at Tina Loza, tag her and ask her some questions. She's so good. She's so quick and so accessible. And hopefully I'll lure her in here again with more questions. Please do send any questions her way. Have a wonderful, wonderful, wonderful remainder of the weekend.
Thank you. I'm going to go have my Saturday glass of wine and you go have yourself a lunch or something like that.
Wait a second, we'll say goodbye to everybody and then we'll say bye everyone. Thank you.
Bye.
Have a good one.